Serunye testified that Johnson reportedly told him, "Why are you making an issue? Go and work. I've seen the document." In his opinion, Johnson was unpredictable and got angry at times. He testified also that he had put his concerns in writing, and according to him, the case had been rushed. Based on the evidence he had reviewed, he did not see a corruption basis for the arrest of the generals. This was how the issue went down at the Madlonga Commission.
By the magistrate, neither were the defense before the magistrate decided on this condition. And for that, that's the first point. But secondly, the magistrate did not give reasons for imposing this condition. And I think those two factors are what swayed the decision in favor of the defense. The High Court saying, when reasons are not given, it's difficult for a party to the presidency to know why a decision was made against them. And there's a constitutional case to that effect. And furthermore, the fact that you are not engaged to address the court on that was also wrong, and that led to the conditions being set aside. On hindsight, yes, we ought not to have opposed it on those bases, but at the time, looking at the Act, it says there's nothing wrong that the magistrate did. He has the powers in terms of 6012 to impose any conditions. Had he given reasons, had he engaged us to address him, that condition would have stood.
We'll come back to it, Mr. Serunye, and because Ms. Johnson did testify to this, specific questions were asked of her about this, and she had certain answers and explanations. I would like to hear your views about it, but we'll get to it.
Thanks, Commissioner.
Thanks, Ms. Paul.
Thank you.
Thank you.
Paragraph 42, the accused thereafter abandoned the Section 63 application. Now, after the magistrate had recused himself, the chief magistrate was trying to arrange another magistrate to take over the 63 application. And the accused then, because of that delay, they then brought a Section 65 bail appeal. Section 65 of the Criminal Procedure Act bail appeal. We again had a discussion, discussed with our boss, and we're giving a go-ahead to oppose the application. And both matters served before the High Court, and the judgments are attached as PS8. The judgment for the bail appeal and the order for the recusal is PS9. In the bail appeal, PS8, the High Court agreed that the presiding magistrate's decision to impose the decision without engaging the parties and giving reasons was wrong in law and therefore ought to be set aside. On PS9, in relation to the recusal of the magistrate, the High Court ordered in our favor to say yes, the magistrate ought not to have recused himself for those reasons given, not engaging you, and the reason given is also not in line with your rugby union matter.
Just before you proceed with the next paragraph, in practical terms, you would have had a conversation about the bail amendment application, the 63. Did you have a similar consultation with the ID regarding now the bail appeal? And did she give positive permission or consent for you to proceed with appealing? Opposing the appeal?
We did, Commissioners, and we informed the ID, and then she gave us permission to go ahead with the opposition on the Section 65.
And when you do that, does she have sight of any of the affidavits that are filed, particularly in opposition?
She does, Commissioners, and I must say everything that we're doing, we're sending to the ID. The Section 63 bail amendment application, all the affidavits of the accused were sent to the ID, and our responding affidavit of Mr. Brian Badayashi was sent to the ID, and the defense then asked for a postponement in that Section 63 bail amendment application. They then on the next date submitted an affidavit by General Masemola in support of the application, indicating that he had lifted their relocation to other offices. And that affidavit as well was given to to the ID, I remember sending an email to the ID asking her that we want to, after receiving this affidavit of General Masemola, we want to respond. Now, how do we do it? Do we subpoena information from General Masemola, or do we serve them with a 28? My question to her was, do we do it by way of a 28 or by way of a letter under your signature being the ID? And she sends me an email to say, serve a 28, which is what we did. And we got further information, which then allowed us to prepare additional affidavits of two other officials, which affidavits we then also handed in support of our opposition. So she was kept abreast at all times of what was happening.
And do you recall whether Mr. Parayachi's affidavit in opposition dealt with that specific bail condition related to whether or not you sought that condition to begin with?
What's the question again?
Do you recall whether Mr. Parayachi's affidavit in opposition set out that or indicated that this bail condition was never sought or anything related to that?
You mean the affidavit which was filed
in opposition?
In opposition
of the bail appeal.
I cannot recall, but if I check on my emails, maybe those can juggle my mind.
All right, thank you.
Yes.
You can proceed to paragraph 43.
Yes, the bail appeal succeeded while I contended that the magistrate was in law entitled to impose the condition. While I contended that the magistrate was in law entitled to impose the condition, I was constrained to concede that he had failed to give any reasons for imposing the crime intelligence entry condition. And it was on that basis, that is the failure to furnish reasons, that the condition was set aside as irregular. The review of the magistrate recusal also succeeded, the court holding that the reasons he had given for recusing himself were not in accordance with established principles. At 44, having completed the Section 65 bail appeal and the review, I had no further involvement in the matter. Paragraph reading my concerns regarding the Mokwele matter. Once I was officially involved in the Mokwele matter, Advocate Tlashwayo and Ramsemi came to me to voice their concerns about the lack of evidence in the Mokwele matter. This is as way back now as 8 August when I became involved. Since there had been no DDPP on the matter before my involvement, I could understand why they felt that they could not address these issues directly with Advocate Johnson due to the power dynamic. Having read the docket on 16 August 2025, I was not satisfied that the corruption charge was sustainable on the available evidence and current formulation of the charge sheet. And as I said, and I said so in writing at the time, my concerns were not the product of hindsight. I recorded them contemporaneously. At the time, 16 August, that Saturday, I produced those queries and I raised a number of questions. I remember one of my questions to them is...
This is the part where the rhetorical question is asked, why were these generals even arrested?
Why were these generals arrested? I couldn't understand. Or why are they charged with corruption?
Before we deal with your specific concerns, just one aspect here where you say that since there had been no DDPP on this matter before my involvement, I could understand why they felt they could not address these issues directly with Advocate Johnson due to power dynamics. What do you mean by power dynamics?
Yeah, the two colleagues are juniors, and it would not have been easy for them to go straight to the ID to raise issues. I'm talking about issues that they were raising with me. They had a lot of complaints that the investigators were not listening to them. They were not carrying out the instructions that as they were delivering to them. It appeared to me, in fact, the relationship was not that good between the investigators, especially Brian Parayachi and Advocate Ramsemi. They were not in speaking terms when I came into the team. I tried to put them together. In some of my emails, I'm saying to them, look, we're playing for the same team. Let's have meetings. Let's talk. Let's iron out whatever problems that we're having. But the two juniors couldn't approach Advocate Johnson, and that is why maybe they felt at ease to come to me and make all those complaints, relay them to me. Not that it was easy for me as well to approach Advocate Johnson. I respect her a lot. I have known her for many years, and I view her as my senior, and therefore I couldn't just bash into her office and say, but what's happening here? Why did you arrest these people? Why this? Why? That is why I put it in an email. I raised all my queries in an email, and I forwarded it to my colleagues. Then I forwarded to her via her PA. And it was not only this one email. You'll see, I think I sent about 2 or 3 where I was saying there's a problem with this case. The way it was investigated, it was rushed. I remember I sent an email directly to her, and I said, it appears this case was rushed. If anything, there might be a case of fraud or there, but the way the investigations were done were just not on.
Just before you continue to your specific concerns, when you say that it was difficult to approach Advocate Johnson, was it purely because of her seniority, or was there something in her management style that made it difficult to approach her?
Look, I don't want to sound otherwise now, but yes, management style as well as in, she could be unpredictable at times, and you know, she's a very good manager, make no mistake. For as long as she was in the IDEC, that organization, and even now we headless as it is for the last week. She resigned last week, Monday, but the organization is continues running itself. It's like a steam train which is on the track. It's all because of the good work that she's put in. The discipline is there amongst the colleagues. She's done so much work that even when we're not having an acting head or permanent head, the organization can continue to run itself with the help of, obviously, the CEO, Mr. Sissoko, and the 3 deputies that are there. I think it was more because of fear that how is she going to react when we take these issues to her, which was also the same for me at the level of DDPP. Not that I couldn't raise issues with her, but you don't know how it's going to end. I referred earlier to a meeting where she was angry with me for raising the issue of a Section 27. She told me straight in front of the 2 juniors, why are you making an issue about this? Go and work. Why? I've seen the document. Why do you keep on questioning, second guessing your investigators? So that is what I refer to here.
In a sense that she, on the one hand, like you said, she's a good manager, but on the other, if you were raising concerns and questioning her decisions, she didn't take kindly.
She didn't take kindly to that, and yes, and she'll tell you straight.